Just want to welcome you all to another of our evening conversations. It's Tuesday, I think 3 Tuesdays in a row, or something like that, that we've been developing for getting your act together. And we've used a slightly different description there. But this evening, we're extremely happy and grateful that Phil Panella is joining us to talk about copyright and other things. And as you probably all know, Phil is director of digital in the Jacob School of Music and is also director of the music library and music IT services. So he comes with quite a lot of strength in his experiences, and just very grateful that he's willing to spend time with us this evening, telling us about copyright. So Phil, I'm going to hand it over to you.
Okay, sounds good. I'm happy to be here. Thank you so much for inviting me. This is a topic that I have been fighting with for, 20, 30 years. I want to just tell you guys now that we're going to do our best to get through as much as we can tonight, but it's a very complex topic. And, I went to a pre-conference workshop, a whole day workshop on copyright in 1996. And I thought, okay, I'm going to learn it all. I'm going to understand what this means, and I'm going to really get my arms around this. And I left that workshop more confused than when I started. So I'm going to hopefully, if my goal is to not confuse you and to give you some practical advice. And I did say, I want to focus it on performers and streamers. People, we get a lot of questions and some complaints about what may appear to be strict policies on how you can use some of the recordings that you get that you make at the Jacob School. So I want to kind of talk about a lot of that and set the stage so that you have a better understanding. All of the slides that I have, I don't know if, Alan, you have a way to distribute these to people, but if not, I'll be happy to share them with you in any way, so don't feel the need to scribble. I also occasionally give a talk or two on presentation style, and I wanted just to say that everything I'm about to do violates all of the rules that I set out to do, mostly because I want to convey the information. So these slides are going to be text heavy, and I'll probably read a fair amount of them because there's a lot of legal stuff going on there, and I am not a lawyer, so I want to make sure I get it right, and I want to make sure that you guys get the best information. So forgive me for the slides. So here come the slides. I'm going to share my screen, and we'll get rolling. Okay. Great. Okay, so I always like to start with this cartoon, which was in the New Yorker. I don't know how many years ago now. Hang on, I want to see your faces. Hang on, I want to do something here where I can actually see you guys. So you can all just chuckle at the cartoon. Yeah, okay, well, that's not working for me right now, so we're just going to move on. Okay, so I want to just remember the golden rule: do unto others as you would have them do unto you. Copyright is a two-way street. We're at an institution of higher learning here where we have composers and arrangers, we have performers, we have people making recordings. So we both create intellectual property and copyrighted materials, and we consume them. So, we have to keep all of these things in mind. And I know what you want to do is do what you want to do. And it sometimes can be frustrating that things aren't as easy as you think they should be. So forgive me for that. Let me also say, I can't see any of you currently. All I'm seeing are my slides, and this is very frustrating to me. So just blurt out if you have questions. The best way we're going to get through all of this is that if you guys just say, hey, I don't understand, or ask me questions, I don't mind being interrupted.
Also, be sure to put things in the chat if you want. I can interrupt Phil as well with any questions that you put there.
Great. Okay, so the number one thing that I figured everyone asks is like, well, and I hear this from students. Everyone posts videos to YouTube. What's your problem? Why do every time I get asked this, I'm like, well, I don't know if you want to do that. Or in some cases, our IU recordings policy prohibits you from doing that, and people don't understand. So that's my goal here. One of my goals tonight is to help build some understanding. And let me just start here as to why the answer usually leans toward the negative more than it should. This is why. These things keep happening, and the world has changed. So, universities getting sued is not an unusual thing anymore. And one of the things we have to do is protect Indiana University, and these lawsuits have not been cheap. And the thing that got me about one of the plaintiffs in one of these lawsuits, this quote here, and he was really clear that, and I'll just read it, sorry. I don't think it can be understated that schools, colleges, and universities are the largest users of copyrighted works. We support arts education. Our job at the end of the day is to represent songwriters and copyright owners and ensure their rights are being protected. If you're using their copyrighted works, you should ask their permission and compensate them. Um, at the end of the day, that's where they're coming from. And the digital world has made it easier for them to track how their intellectual property is being used, and has provided some opportunities in some organizations that are basically, out there just watching. So we at the same time have to be a little more careful about what we do. And at the same time, we're opening the blinds to show everybody that how great we are. Look at all the things we're doing. So at one time, when 20 years ago or even more, when Alan and I were students, we gave a recital and we didn't really worry about a copyright infringement because except for, me and my mom and dad and the 6 people who were there for my recital, nobody knew what really happened. Now we put the programs on the web and we share our PDFs and we publicize it on social media and then we stream the concerts. And so we're kind of doing it to ourselves in a way, but the right thing to do is the right thing to do. So here's what we're going to do. I want to be clear that what we're going to talk about tonight is United States copyright law. And I'm sorry, the dogs are going to act up. I knew it. And so I want to talk, if you're from another country or you're going to go back to Canada or some other place, I can't speak to their copyright laws. I apologize. It'll be okay. There is, of course, something called fair use that many of you may take advantage of for what you want to do. But from the university standpoint, from the Jacobs School standpoint at least, I also want to just remind everyone that as an educational institution, besides safeguarding our legal situation, not getting the university sued by what we're doing, I also feel a certain obligation to do the right thing and to teach students what that right thing is. And of course, all of these cases, as you know, are, they're questionable. And the only way to really know if something is legal or illegal is to get sued and have a judge rule, and then you'll have a ruling at, yeah, that was okay and that wasn't okay. So it's hard to say. We do take advantage of fair use as much as possible, and of course, we always try. But it's become more and more difficult in recent years to say, well, isn't that a fair use? And I'll talk a little bit more about that in a minute. Okay, so I think the dogs settled down. So we're talking about U.S. copyright laws. And I also want to talk a little bit about the Jacobs School's policies that govern the recordings that you guys will make here at the Jacobs School. And so if you are a composer or an arranger and you have other questions, and I know a few of you submitted questions about publishing, this will be less dealing with those issues, but I will hopefully answer your questions to a certain degree, and then ask Naz Pantaloni, who I'll make sure you get his contact information, and I'll tell you more about him in a little bit. And I've spoken to him, and he's happy to talk to you guys about this. Someone with a lawyer with real expertise. Okay. So we've already had the interactive part, but I was going to start with a couple of questions because I'm always intrigued by how students respond to this when I talk about copyright. So, it's pretty common that people make photocopies of parts and scores and things that they want to use. Or I will freely admit, even though I'm being recorded, that I have ripped audio from CDs and downloaded from the internet. I mean, I was around when the real Napster, the good Napster, was around. And so I still have some of those files that I downloaded. I hope there's laughter and smiling at least. Can't see you, I hate that. And so I ask you, and this is for anybody, jump in, students especially, how do you justify it? If you're gonna make a photocopy and someone says, that's probably against the copyright law, what's your reason to say, well, it should be okay, or I shouldn't get in trouble because? Do you have anybody want to jump in with an answer? Don't all jump in at once.
Out of print and I can't get a copy of it.
Okay, out of print and can't get a copy. That's actually a reasonable one, but not without some reason for. It doesn't mean it's a gimme, but okay, that's not bad. Who else?
My teacher told me to learn it.
Okay, yeah, that's fine. Anybody else?
I don't want to make the student go and buy music. I don't want to deal with the discussion of money and can they afford to buy more music.
Yeah, okay. And if you're the teacher giving the lesson, how would you feel if the answer was, well, I don't know that we should have to pay you because we don't want to deal with the issue of money with this, I'm kind of playing a game here, but usually there's someone who says, well, I'm a student and so I should be exempt from this thing. Or I wouldn't have bought that recording anyway, so they didn't lose any money. Or I need it and I don't have the money now, but after I've started my career, I will be sure to always follow the rules. All of these things in the end are violations of the law. And let me also say up front, even at IU, when we're faced with making some decisions about streaming something that perhaps we haven't cleared all the licensing issues yet, but I'll say, all right, let's just do it anyway and not worry about it. It's always about risk and reward, right? So, if it's a low risk, even if you got in trouble, it probably would be a very low, you wouldn't be in that much trouble. No one's going to jail. You're not going to get fined $150,000. You have to sometimes make those assessments or ask your lawyer if you have one. So, all right, that's enough of that. I, again, am not a lawyer and I'm not giving you legal advice, but I do feel the need to just say a few things regarding the law. So this is, the part I hate the most. But we need to understand these things. First of all, copyright is granted once a person has created an original work and fixed it in a tangible medium. There is no need to register it with the Copyright Office. It doesn't matter if it's still in manuscript form. It doesn't matter if it does or doesn't have that C in a circle symbol that you may have seen sometimes. So know that right now, if you're scribbling on a piece of paper or doodling some artwork, technically at the end of this, that's copyrighted. You have fixed it in a tangible medium, something that you can share. And a tangible medium could also be electronic formats. RAM can be a tangible medium, something that is fixed, meaning that you have done something and completed it to a certain degree and said, this is my thing that I've created, okay? So don't think you can get away with things there either about, well, it was still a manuscript and it wasn't published yet or anything like that. Okay, the copyright law, I'm not going to speak too much about the specifics here, but I want you to at least see the things in red there. The copyright law gives the owners of the copyright, so the creator of, say, a piece of music, the right to do all 6 of these things, among others, but the ones I want to really focus your attention to are number 3, gives them the right to distribute copies or phono records, which is any kind of audio video recording now. Just know that they use the term phono records to mean recording, sound recordings mostly. To distribute copies of the copyrighted work for sale, transfer of ownership, rental, lease, or lending, to perform the copyrighted work publicly, and in the case of sound recordings, to perform the copyrighted work publicly by means of digital audio transmission. So pretty much, if someone writes a piece, a song, whatever, they have all the right to make copies, to distribute copies, to do all these things with it, and you really don't without working with them on these issues. So what does it mean for music? This is kind of what I just said. They can collect royalties. If it's performed live in public, they're owed a royalty. If you hear a recording that's playing in a restaurant, bar, etc., the people get paid for that. On radio or digital platform, people pay licenses for these things. And it was not, I don't know if this is still kind of enforced, but it wasn't uncommon in the past where people had jobs where they would travel around and hang out in restaurants and bars and write down all of the recordings that played over the sound system for these places that hadn't secured proper licensing. And at the end of the night, they made a report and said, you used all of these recordings, you've paid for none of them, and you now owe us X thousands of dollars. So these things happen. Okay, so let me talk a little bit about the Jacob School's policies right now. So I'm sorry for all the tech stuff here, and this is mostly for your reading pleasure later, because I'll give you the slides. But the Jacob School has a policy on the rights of ownership and use of audio-video recordings. It's on our website at that URL, and there'll be all the URLs in the final slide, too, that you'll have access to. But one thing I want to highlight here is that the trustees of Indiana University own all the copyrights and audio-video recordings of live concerts and recording sessions and all other audio-visual materials made using JSOM facilities or resources. Oh, come on, man. So without exception, your recital, any recordings you might make. Excuse me, I'm sorry. I'm going to close the blinds.
And everybody, just remember that if you have any questions, put them in the chat, right? And I'm sure you have lots of questions about how this impacts you. Hopefully, he'll be covering the licensing that Indiana University has for performing of works and what that covers as a student. We'll ask him about it.
Okay. Hopefully, this will do better now. Um, so, as I was saying, so the trustees basically own all the recordings that get made at the Jacob School. You can get, of course, you're entitled to a copy, and you will get, you can ask permission to do things with those, but at the end of the day, the copyright in the recording belongs to the Jacob School. All recordings have two copyrights, right? There's the copyright for the work that you performed. So if your friend wrote the piece, so that person has ownership of the work. But then when you make the recording, there's also ownership in the recording. Now, but according to this policy, which, by the way, whether you know it or not, you agreed to when you accepted admission to the Jacob School, among all those forms you signed when you said, yeah, I'm going to come there and pay my tuition, you agreed to this policy. So FYI, in case you didn't know. So the recordings are technically owned by the Jacob School. You're killing me, man. And just this other part, I want to make sure that, except with the approval of the dean, no recordings can be reproduced, adapted, distributed, displayed, performed, or otherwise used in any manner or media for any commercial or other purpose. So we hear this a lot. So I get my recital recording, and I want to go now post it on YouTube and do all these things. And we know it happens, but technically, you don't own that recording. You shouldn't do that without permission. So most people don't really pay attention to this and don't know this, but I want you guys to know that. And some of it is to protect IU, that you may have performed works that were not licensed for that use. And for a lot of our recordings, when we license things, so we rent music for performance, we always say it's for the recording will be made for archival purposes only. So when we give you that recording, technically it's for your personal use, which in the old days was that it was for your personal archive, your review and study, and so that you could listen back and hear how it went, and as part of your educational work at the school. Posting it on a public website for advertising or other things like that kind of gets murky as to how we license some of that music. So hold that thought. We'll get a little bit more about that. So let me talk a little bit about performance rights and what this means, because most people don't understand that. Well, I bought the music. That means I can just perform it wherever and whenever I want, right? So here's a good example that I like to use. Gene O'Brien, now some of you are so young you don't know, he used to be our executive associate dean, and he's a composer, and still, I think, teaching a few students. And so this is a work that we have in the library that he composed in 1996, The Clouds of Magellan. And on the flip side of the title page is this note that appears there that makes it pretty clear. Please note that the purchase of rental of this music does in no way conveys the right of public performance. In order to secure the right of public performance, a license must be obtained from, and they refer to the Society of Composers, Arrangers, Publishers. We'll talk more about ASCAP in a minute. So this is technically the law, right? That if you have a piece of music and you want to perform it publicly, you're supposed to get a performance license. Now, this doesn't apply to things in the public domain, which we'll talk about in a minute. So I know you're like, really? This is really the law? So the law gives copyright owners the right to control public performances. It applies to a live performer or recordings of them. Broadcasters, as I said earlier, they get licenses to broadcast things. And note that if you suddenly want to do an opera or a musical, something theatrical, that requires a whole separate license called grand rights, which we do every year for all of the operas and ballets, and ballet is even more complicated. So I know you're saying, oh God, what have I got myself into? Are you saying I need to get a license for every piece I perform? And the answer is, well, it depends. I'm not a lawyer, but I've learned enough to say that. It depends on what you're doing and where you're doing it. So let's start with the easy ones as to why you wouldn't need to get a license and why a lot of what we do is pretty easy in many respects. So works that are in the public domain are, by definition, freely available to you. Now, so what does it mean if it's in the public domain? And I'm not going to get into the technical, of course, now my dogs are eating, so you're hearing eating and slurping of water, but at least they're not barking. So the most common way a work gets into the public domain is its term of copyright expires, right? Composers don't get their copyrights to last forever, although some people have tried to extend them in perpetuity. But for our purposes, a general rule, again, this is not legal advice, anything published before 1925 is pretty safe to assume that it's currently in the public domain, right? So you don't have to worry about Mozart and Beethoven and Brahms, and those works are all now clearly in the public domain, and you can perform them without worrying about getting any kind of licenses. You can record them, You can make arrangements of them. All those things are fine. I do want to just mention that modern editions of old works can be clunky, and I tell this story all the time. A few years ago, we performed The Barber of Seville. Rossini is no longer in copyright, and we were clearly, it's a public domain work, and we ended up paying over $1,000 to stream that because the maestro insisted that we use a new critical edition that was just published a few years earlier. So that's one of those instances where, clearly it's an old work that should be in the public domain, but they wanted to use a recently published edition, which is now in copyright. So yeah, you could make your own edition of the Beethoven symphonies and sell them and hold people, accountable for their performance rights on those. So it's much more complicated than I'm making it out to be here. So don't go off and do that and say, Phil said I could do this and not, owe me money. You should get yourself a lawyer if you're going to publish your own editions. So, but know that this can be a thing. So keep that in mind. Okay, so yes and no. If the
You went
Sorry,
on.
Phil. My fault. I just muted you by mistake, Phil. Sorry.
I got nervous there when it said suddenly I'm muted. I'm like, I didn't touch anything. No problem. And that was my best line of the whole talk. Anyway, so if something is not in the public domain, it could be covered by something called a PRO, right? So there are performing rights organizations that are because early on they realized that, well, this is unsustainable. If every performer had to clear every work they performed with the composer or publisher, no one's ever going to be able to conduct any business here. This is never going to happen. So there are 3 major performing rights organizations in the United States that there's another one that I'm not going to talk about that we also get involved with sometimes, but the 3 are ASCAP, the American Society of Composers, Authors, and Publishers, Broadcast Music Incorporated, BMI, and CSAC. And originally that was the Society of European Stage Authors and Composers. They're no longer that. They're just a private organization that does this kind of work. So these organizations provide performance licenses, and they largely do so in the form of blanket licenses, which is what IU has with these organizations. And what this means is that at the end, we don't have to license each work. We perform these things, and sort of at the end of the year, we settle up. We pay them a bunch of money up front that sort of allows us to perform music on our stages, play music around at the football stadium, and recordings and things like that at the Starbucks at the Union, and then all of these things get settled up by lawyers somewhere that we don't need to spend time on that. So, and I just want to also mention that most of the time this type of thing is done by the venue. So if you're getting hired to play at Carnegie Hall, you probably don't need to be worried about licensing the works you're going to play. The people at Carnegie Hall should be asking you, what repertoire do you want to play, and they do the work to make sure that these things are covered. So I also will throw in, though, that in recent years, some publishers have argued with us that a live stream is not a performance. We have always been we've been told by legal counsel that the performing rights organization contract, the blanket license we have, allows us to perform these works. And a live stream, just the live stream, not an on-demand stream, but the live performance, if we stream that on the internet, is considered a performance, so we didn't need any additional licensing. We've had a few publishers, as we've been renting the music, and say, well, that's not true. You have to pay us a license if you really want to stream that piece. And we thought about pushing back, and usually it's a nominal fee, and we're like, yeah, we don't have the time to deal with this, so it's easier just to pay them the money and make it go away. But I am concerned about that a little bit. And the other part of this that has changed in recent years, as opposed to the good old days, in the good old days, most composers were associated with either ASCAP, BMI, or CSAC. They did it to sort of deal with this issue, that they didn't have to worry about it in large part. It was also an avenue for them to get their works discovered and out there. But these days, in the advent of the internet, self-publishing, people being able to publicize their own works, a lot of them don't bother registering with performing rights organizations. I mean, part of it is, I think ASCAP takes 11% of whatever fees that you could collect on your own if you're a composer. So it's not a given anymore. So we end up searching these things in all these databases, and now you'll have the links so you could search yourself if you want. They have these easy websites where you can go and plunk in a composer and a title and see if it's in one of these. So for our purposes at IU, if it's in the ASCAP or BMI database, we're good to go for a live performance. If it's not, then we have to go the next step and we have to go contact the composer or the publisher. And that can be a chore in and of itself, finding that who really owns this thing. Who do we need to be asking permission to do this, and who do we pay the money to if they ask for money back? And I'll also just add that the money question that I'm sure a lot of you are asking, like, well, how much is this? And sometimes they say, oh, don't worry about it. Just, it's gratis. Do it for free. We're happy that you're doing it. Thank you for asking. Other times it's a ridiculously high amount, and we've usually said, yeah, well, then no, we're not going to stream it. Like, we had somebody once quote us like $1,000 for a live stream, and we're like, yeah, that's not happening, man. Most of the time they're in somewhere in the, I don't know, $75, $100 range, 125. In there is not uncommon for some of the things we do. And sometimes we also add on to that some on-demand licensing. So that's where we keep it up on our website for the performance, the video, the performance for like a year after. But just remember, asking for the permission to perform it means a composer might come back with that high price, and then you say, oh crap, I can't afford that. And then you have to make a decision. Like, you can negotiate these types of licenses are certainly not statutory as mechanical licenses that we'll maybe hopefully get to, where it's a set price that they have to charge you when you pay for certain activities. This can be anything. I always liken it to, like, we're two guys sitting at a bar and they write a number on a napkin and slide it across to me, and I like peer at it and and I cross it out and write a different number and I slide it back. That's really the way it's been right now. It's getting better as this becomes more and more common. And after this year of pandemic performance where everybody's sort of grappled with these issues, maybe it'll get easier. I hope it's get easier. Okay, I talk fast and I talk a lot, and I'm trying to cover a lot. Let me take a breath and ask if you guys have questions.
Yeah, there are a few questions in the chat. Caroline, do you want to open up your mic and ask?
Sure, yeah. So I had a couple of questions, and the first one was about the Joshi recording studio. So, like, hypothetically, if I were to go in there and record something, and like ideally maybe I want to make a record, can I not do that because of these rules where that technically belongs to Jacobs?
You can, but you need to make arrangements. Like, you up front, you need to say, look, this is something that I want to do for this purpose. And usually it's a question that, all of this is the dean's got to sign off and say, sure. We deal with this with guest artists too, who come in and give a recital, and sometimes it gets written into the contract that pays them for giving a guest recital. Other times it happens after the fact, where people are like, what do you mean I don't own that recording? So the best advice I can give you is to be really clear up front and say, I would like to make this recording for this purpose, and then we discuss what the steps would be to make that happen. And it's not that complicated usually. And so the Joshi is an interesting thing because they're there to learn to make recordings too. So it's part of their educational experience, and so there are other rights at play there too with the recording engineers that you want to talk about as well. But generally, we are the venue, the people who own the property on which you're making these recordings, the expertise and the equipment and all that stuff. So it's not completely unreasonable to say that IU would have a stake in this, but it's not that big of a deal. And let me be really clear too. IU isn't doing this because we own it and then you become famous and we're going to say, well, we have Caroline Goodwin's senior recital and we're going to now sell this for the low price of $9.99 a download. We have Joshua Bell's artist diploma recital. We would never, in that agreement, if you read all the fine print there, I mean, maybe the letter of the law is that we probably could if we really wanted to, but we wouldn't do that. We principal artists, named people in the program, soloists. If we were to ever do anything, like I don't know, 10 years ago we released legacy recordings, we called it. This is back when we were still making CDs, so it was a CD project, and we released a 2 CD set of kind of the greatest hits of the Jacob School from the beginning through whatever that time was. And we wouldn't release anything unless we got permission that, yeah, we want to include this on this kind of recording. So we're not making money off of those recordings. That's the point I want to make. Like, oh, sure, you guys are keeping all the rights and you're going to sell CDs and make money. That's not what it's about, and we wouldn't do that. If there was an opportunity to do that, we might contact you and say, hey, could we do a project using your recording? And then you would have the right to say, sure, if you cut me in on a slice, and we can work that out. So did I answer your question? I don't know that I did.
Yeah, no, you did. So my other question was just like, how easy or hard is it to like get permission to like basically distribute your recordings, or like in this scenario where I make a record and you made it sound like I would just have to be upfront.
I think you need to be upfront and have a conversation with the dean probably, and several of us to sign off on. Okay, I mean, look, the Pacifica has done some recording projects in our hall, so we don't claim to own those recordings. I don't think the Grammy Award winner was the one that they made in our hall, but we don't have any claim in that. But upfront, they said, we want to do this project. We'd like to do it in our hall. We're going to bring in our own recording engineer, as a matter of fact, to do it. And that was all legit and legal, and papers were signed, and it wasn't a big deal. So I think it's just, and if you're going to be working in the Joshi, you would talk to Professor Strauss about that, and he would be able to walk you through the steps. And, Dean Allen would probably just need to say, yeah, of course, no problem. It's more about making sure that these things, we also have to protect ourselves from this scenario, which is a real one. As the director of the library, it came to me. There was a recording that we found for sale, and it was of a pianist named Jonathan Ogden, who was on our faculty briefly in the 80s, a couple of years. And he had an interesting career. And this recording that was for sale from this recording company said Jonathan Ogden recorded in Bloomington, Indiana, and what this date in 1980, whatever. And I said, he was on our faculty then. Could that be our recording? And we actually got Conrad Strauss we pulled the archival recording, and we got a hold of this recording. And sure enough, it was our recording. And this person was selling it, and the Office of General Counsel, not me, not any of us at the school, sent him a letter I keep handy because I love reading that letter. It was so fantastic. And it was like, you have done this, you violated our copyright, and you will now send us any proceeds you have made from it, and you will also pay us this additional fee, and you will destroy all the copies of the recording. And this was one of these instances why I like to do this kind of talk, because the person who made the recording said, well, Jonathan Ogden's widow gave me that recording and said I could do it. She gave me permission to do it, and she gave me the master recording. And it was the same kind of thing, that he, as a faculty member, didn't really have the rights. They're owned by the trustees of Indiana University. And so now, had he asked and said, I'd like to release this commercially, and it's, a solo recital of me, we probably could have made those arrangements. But here we were 20, 30 years later, and it got a little messy. So,
Phil, there are two more questions here. Alex, do you have your questions answered by what Phil has already said, or do you have another question? You can open up your mic and chat. And then while you're thinking about that, Kesley, maybe you can just jump in and ask your question.
Sure. If I make my own personal recordings, I record a piece in an IU venue, does that recording still belong to Indiana University?
Yeah, I mean, I suppose that the letter of the law, maybe, yeah. Yes, I guess, according to that policy. But look, if you're bringing in your friend, the audio engineer, who goes to school here, and you guys make the recording and we don't know about it. And look, we fully expect that people are making recordings for graduate school auditions, all kinds of competition auditions and things like that. So nobody's going to get in trouble for doing that kind of thing. It's more just the understanding that the school does have a policy about this that you should follow. And depending on what you want to do, like, we don't want to find out that there is a commercial release of a recording that was recorded in our hall. And we're like, how did that happen? So it's better just to say up front, I'd like to do this project. Is there a way that I can do it? And we could probably work out the details.
Okay, and then my other question is that, like, for licensing for my recital, and it's not happening in one of the main venues, so I don't know if they care as much. Do I need to secure that myself? Because I know I'm performing several pieces that are under copyright. And if I were to want to stream that content myself, like on Facebook or YouTube, would I need to secure that permission from the composers myself?
Officially, yes. Again, this is one of those moments where I know I'm being recorded, but I mean, chances are no one's going to notice and you're not going to get. Where are you doing your recital?
I'm doing it in Sweeney, but with one is, like, I have been in direct contact with the composer, and I would like to be respectful of his work. And if he
that's the reason why I would say, I would advocate you do it, because it's the right thing to do. I mean, Caroline just gave a recital, and there was an IU composer, and there was also someone else out there in the world and I don't know if Caroline, if you want to mention how complicated that was to contact him and get his okay to perform his piece.
Truthfully, it wasn't bad at all, but it sounds like Kesley, you've already been in contact with some of the people you know. So it was Alex Tedrow. I did some pieces of his that I commissioned on my recital, and then also Jonathan Stinson, who I think was like a 2003 doctoral comp graduate or something like that. So I just had to find his website and like send him a little note like, hey, I'm thinking about doing this on my recital. It's gonna be live streamed. Is that okay? And he was like, oh yeah, go for it. He was very supportive, and of course so was Alex. So in my experience, it has always paid off to just ask, but I also haven't come into contact with anyone who's trying to make a lot of money off of that kind of thing. So
Right.
I don't
And
know.
then
Yeah.
is it,
Go ahead.
sorry, is it possible that also they would allow me to like display that recording just if I asked permission after the fact, then and they were okay with that, then I could do that. That would be fine.
That's something else that you should request permission to do, and that they could charge you for. Technically, that is a synchronization license we're going to talk about in a minute, if you have a video of you performing their works. But as I've said, and as Caroline experienced, oftentimes they'll be like, no, great, thank you for performing my piece. But it runs the gamut. We've also had publishers be really difficult. And so it's hard to say. And you need to be prepared if you ask the question. Well, actually, the biggest problem is they don't respond. And, I would advise all of you, if you're going down this path, leave yourself plenty of time. I mean, months if possible. Like we'll start this process like with the operas for next season. We'll probably start in April. And we've had, Mark Adamo's Little Women, which was just performed last time. The first time we did it it wasn't the first, but several years ago. We couldn't get them to respond to our request to pay to stream these performances live. And Mark Adamo himself, who of course can't grant permission because the publisher owns the rights to this now, called them on our behalf and still had trouble getting it worked out. So these things can take literally 3 months at times. But there again, though, if you're doing that, I kind of fall on, well, look, we've been trying, and if we do, and we're going to do it, and if they come after us afterwards, go ahead, sue me, and I'll be happy to stand up in court and say, yeah, we wrote, keep good records of every time you email, try and email as much as possible so you have it in writing, and document when you made a phone call, and so you can say, look, I contacted you on this day and this day and this day and this day and this day, and you never responded. And so that helps a lot than if you just said, I didn't think I had to. I didn't care,
And then I have one more question. We have a student organization, Classical Connections, and we've been doing streamed Zoom concerts. Is it our responsibility as organization leaders to make sure that these works are accounted for if we're doing streaming concerts?
Zoom is an interesting question that I don't have a good answer for, and I would want to let me put you in touch with Naz on that one, because probably, yeah. I mean, you're performing a work publicly, although how public is it, right? So this is how I kind of fall on this. If you're doing a master class and it's you and 10 students on the other side of the Zoom, I don't know. I mean, this is where Nathan's comment, I think it was Nathan, I couldn't see at the time, but I'm assuming it was Nathan, about fair use. Look, that's probably a fair use. It's an educational activity. You're not broadcasting it widely to anybody in the world who wants to see it. It's a small audience. It's a closed audience. That feels like fair use to me. And I think you should feel pretty comfortable with that. Now, if you're doing a webinar and you're posting this link on every social media platform and saying, come watch me give the premiere of so-and-so's, the Indiana premiere of so-and-so's work, that feels a little different. But if it's a closed thing in an educational setting, it's probably fair use. But again, I am not a lawyer.
That's great. So I have a question actually from somebody who writes their own music. And so if I write, this is from Alex Turner, if I write and record an original piece of music in the Joshi studio, is it mine to do anything I want?
Yeah, probably. Yeah. I mean, you should talk to Professor Strauss about it. And I can't imagine the school would hold you up on this, even if you won a Grammy with your recording. But acknowledging that policy is there and asking the question and saying, I intend to do this recording project of my own music, goes a long way for somebody. Then you have someone send you the email back saying, yeah, no problem, good for you, go for it. Yeah. But the letter of the law is that, yeah, technically you could claim it if they really wanted to, but we wouldn't.
Who's our contact person for those questions when they arrive?
for copyright related questions, I mean, you could start with me, and if it's not me, I will quickly pass you on to Nazareth Pantaloni, who works in the main library, who's a copyright lawyer and librarian. So,
And then we have a quick question related to editions. Christine, do you want to open your mic and ask?
Hey, hi
hey,
Phil.
Christine.
Thanks for doing this. Hey, so I'm putting on my Bloomington Symphony hat right now, and also as a conductor wife here. The issue of Baron Writer, right? Like so many conductors and performers would much rather have that than some of the other, I'm not going to mention particulars. What are your tips for navigating the modern editions when you want the better or more preferred edition of a public domain work? Here's my dog.
Yeah, I mean, it's hard. You know, that's a tough question. But like with our Barber of Seville example, I said, would anybody know? I mean, really, like if
Can you hear the articulation, right?
yeah,
all the errata that we fixed.
How different is it? Would somebody really be able to tell 2 hours and 30 minutes in that, oh, there's the E flat, that's my edition? I mean, really? Like, come on. You know, again, I always joke with our IT projects, there's the right way, the wrong way, and then the way we'll do it, which is, you know, sort of in between there. And I would say, look, the right thing is that if you're going to want to use a critical edition, you should purchase that edition or rent it is more likely what you're going to end up doing, and pay the fee. But I think that the work there is determining, is it worth the money? Is it that much different than the Dover edition or whatever the public domain edition is? And IMSLP is really your friend on this, because if you can access those scores there, like if you're not sure, is this in the public domain or not? If you can access it on IMSLP, they're pretty good at you know, posting things that's a good check on your copyright question. I don't know that I'm really good answering your question very well, except that, yeah, those modern editions are nice and they're printed on good paper, and, you know, the notation is really clear, but you get what you pay for, right? I mean, that's what you're paying for there. So I don't know. So anyway, we should move on,
Right.
but I can talk more about that sometime.
Excellent. I think we're good to go.
Okay, we'll go back to the show here, and you'll all disappear from my screen, unfortunately. Please do interject as we go.
Kesley's waving at you.
Thank you.
I said bye.
Okay, here we are. Okay, we talked about that. So the on-demand question. So what I mentioned before, the performing rights organizations license a performance. But as I mentioned in response to one of your questions, so if you record your recital and then want to post that somewhere, and we'll talk about YouTube in a minute. Technically, you need a synchronization license. So this is what happens when you want to set music to film, or you want to make a music video and that kind of thing. You're synchronizing audio and video. And so for all the things on the IU Music Live website, for example, that appear there after the live performance is over, I mean, most of them, we kind of do all the public domain things because they're freely available for us to do. But sometimes you'll see that there are things there. We have paid for licenses to do that, and we have this massive spreadsheet that, you know, every month something rolls off that we're, okay, that license is over. We need to either continue it, or we need to just take that down now. So keep in mind that the performing rights organizations just cover a live performance, essentially. Now, so let's say, what about YouTube? Because I know this is what most people do, and it seems like this is the way the world works now. So luckily, in recent years, and this isn't that long that this has been happening, YouTube and Facebook and I think all the major social media platforms now have a license with the performing rights organization. So for example, YouTube has an ASCAP and BMI license. So you can do your thing from YouTube Live and then keep the video up there. And the way that this works is that the publishers are getting the advertising revenue with them. They've made the deal with YouTube. So again, remember, this kind of licensing typically is the venue. So in this case, YouTube is your venue, and they have a license that they've paid for, and you can host your things there. So this works pretty well. But again, you remember, not all music publishers and composers are licensing their works through the performing rights organizations, A, and B, and sound recordings, same way. Like a lot of the recording companies are saying, yeah, you can, you know, so you can record your cover song, and you can also have the original recording on there because they're getting ad revenue. That's their deal. But most of these deals that they have are with music publishers like Sony and Warner and Universal, not Schott and Schirmer and Baron Writer. So you can't count on all of your works appearing in these, being covered by these licenses. Now, is somebody going to take the time and figure it all out? It's hard to say. But I will also add that when you use these services, YouTube in particular, their algorithm is really clunky, and it's gotten a lot better. But I'll just tell you this. So I mentioned earlier, for those of you here at the beginning, last November or December, it was December 2nd or 3rd, we did a special Facebook Live event. In addition, we rebroadcast last year's Nutcracker since we couldn't have an in-person Nutcracker for the first time in ever. And so we simultaneously streamed it on our IU Music Live page and Facebook Live, because Tchaikovsky's in the public domain. We own the choreography. We obviously own the recording at IU. 7 minutes in, if you were watching the Facebook Live stream, it got shut down, and we were sent a message saying we violated copyright on a commercial recording. So weird things happen there, as my only warning. I've had 2 students in the last couple of years say, for a competition, I'm supposed to upload a video of me performing, and this one person was performing Chopin, I think, and it was flagged as a copyright violation, saying it was Martha Argerich, which I was like, hey, good for you. They think you're her. But it was clearly the student playing in our hall. So just beware of these kind of rules. But I have a bigger concern about YouTube that I want to warn you about. And I've just always had this sort of bug in my, what about this. So you remember when you signed up for YouTube? I'm sure you don't. There was a terms of service agreement that you clicked and you said, yeah, I agree. Because you can't be on YouTube if you don't, right? Well, do you know that agreement, and I checked this just recently to make sure that it's still happening this way. There's a long page of terms of use that you agree to, and among them is that you grant YouTube a worldwide, non-exclusive, royalty-free, sub-licensable, transferable license to use, reproduce, distribute, prepare derivative works of, display, and perform the content in connection with the service. So when you put something on YouTube, YouTube has all the rights. Technically, they own it. And you can take it down, but they still have rights to keep it on their servers. And including, they say, making derivative works. And so that's like, mostly in YouTube parlance, this is a mashup, right? But they could grab your content and make a different video using your content, and you have no claim to it. So they can do whatever they want, essentially, with your work. So a derivative work is like an arrangement or a remix kind of thing. And also, you grant YouTube the right to use, reproduce, distribute, display, and perform such content as permitted through the functionality of the service. So they got your stuff and they can do whatever they want with it. Now, again, you're one of, a billion users. Who knows what's the chance? And if they suddenly highlighted your video, you'd probably be ecstatic, like, oh my God, they're using my video. But still, think about what that means for you. And the license, it says, is perpetual and irrevocable. So they got it. It's always going to be on their server. You can delete every video you own right now off of YouTube. It's on their servers forever, and you have no claim to them. You can't tell them to take it down. So just know that that's there. And just if you had a question about Facebook, I double-checked this one today too. So there's a long list of saying your content is your content, and you own all the rights in your content, and we're so proud of all these things. And then they say, then there's another paragraph. However, to provide our services, we need you to give us some legal permissions known as a license to use this content. This is solely for the purposes of providing and improving, blah, blah, blah. And then the red stuff, you grant us the same language as YouTube, a non-exclusive, transferable, sub-licensable, royalty-free, worldwide license to host, use, distribute, modify, run, copy, publicly perform, display, all the stuff, and create derivative works of your content. So I haven't looked at Instagram Live and TikTok. I'm sure it's the same kind of thing. So just know when you choose to use those services, you are opening yourself up to something there. Again, how big a risk is that? I don't know. I got stuff on YouTube. Everybody does. But the world is a crazy place. Okay, synchronization licenses. As I mentioned earlier, if you want to use a musical composition in an audiovisual work, but including like your recital performance, technically that would require getting a synchronization license. So that's what we end up getting when we want to make a video. So when we recorded the Pacifica a couple of weeks ago in our hall, I think there's one work there that was needed licensing. If we want to make that available on demand, we go back to the publisher and say, we have this recording, we would like to make it available on demand for usually a period of either 6 months or a year. We shoot for a year unless we can't afford it. And then essentially what they give us is a synchronization license. And again, these are those licenses where they can make it up as they go and say, okay, $1,000. And then we say, nah, and then forget it. And they say, okay, how about $500? Well, okay, maybe. What about 250? And that's how it goes. So, okay, here's the step-by-step guide, which I want to give credit to the Barbershop Harmony Society. Believe it or not, they have this website. You'll have the link where they have, here's the step-by-step guide that they did it last spring when I guess everybody had to move online. So you can keep your barbershop quartet going through the pandemic. You can perform online. And I felt really good, like, oh, thank God, they said all the things that I say we should be doing. So I think I got it mostly right. So, here are their steps. Step one, you got to figure.
Phil, before you do that, did you pay for this?
No, actually, I'm violating their copyright law, I'm sure. I'm publicly displaying their intellectual property. I'm giving them credit. So yeah, thank you for pointing that out. But yeah, sue me. I said nice things about them though, didn't I?
It's good.
Okay, so step one: determine who owns the copyright of the works you want to perform, or if first of all, if they're not in the public domain. So remember, prior to 1925, probably in the public domain. Don't worry about it. After 1925, you got to do a little digging and find out. So if you can look at the music and find the publisher, but please be aware that this is a detective job that you're going to end up doing. That piece of Dean O'Brien's that I showed at the beginning that had the statement, on that is the publisher, MMB Music. And if you wanted to really track down who now owns that work, MMB no longer publishes music, and they sold their stuff to somebody else, who then sold their stuff to somebody else, and it's a mess. Sometimes it's a lot of work to figure out, who do I pay the money to? Who do I need to call to ask? So not in public domain. And this is, again, for you now going off on your own and doing something, not at IU. We handle this stuff at IU if we're streaming your event. This is kind of these are the steps we take. We look in the performing rights organization databases and see if the works are covered there. Hopefully they are, in which case IU has a blanket license. And then in that case, you might ask Carnegie Hall, like, hey, you guys have ASCAP licenses, right? Because this work I know is there. And but if you're on your own doing this is something you need to consider. Then you should contact a copyright holder and say, I'd like to perform this work and I would like to stream it. If you're striking out, other places to check are the United States Copyright Office and the Harry Fox Agency, which I'll talk about more in a minute too. All right. Step two, then, decide where you're going to stream it from. So if you're doing YouTube or Facebook or any of these others, again, they have now the performing rights organization licenses. So if you're doing one of those, it's covered. And you can go forth and give your performance, put your recording up there. If you're not doing one of those and you have your own server that you want to use, and we use our own servers here at IU, that's when you have to go do the work of asking permission and getting a license potentially. So those are the step two. I mean, step three, if you're not doing YouTube or Facebook, then you want to get a synchronization license to put it up publicly on your website forever and ever. And just let me use this opportunity to talk about your recital recording, because this is the question I get a lot too. So we give you a recording of your recital. Congratulations, good job. And then we tell you, yeah, but it's for your personal use, and don't think about posting it anywhere. And again, we expect that you guys have websites and social media presences, and especially young artists who are trying to go out and build a career. If something went extraordinarily well, we would want you to showcase that. Now, this is where the fair use thing comes in. If you're going to put an entire piece that is copyrighted, all three movements of that sonata, you probably want to talk to us about getting permission, because we own the copyright in the recording, and then the composers, because that recording wasn't licensed when we made it, right? I mean, maybe it was covered by our blanket license, but there's a chance it wasn't licensed. So you want to make sure the composer gets paid, and we can indemnify you to go off and do that. If you want to showcase a clip, and don't ask me like how long is 30 seconds enough, or I don't know. It depends. And this is part of the fair use examination that hopefully I'll have time for. When are we done? Are we about done, Alan? Is this the time that we're supposed to be done?
Well, we could keep going.
I'm happy to continue for a little bit because the dog's interrupted, and if you guys are,
I think this is really important to go through, so feel free to just continue. And to everybody, this is being recorded, so we can put it on the web with permission.
Of course, I'm available by email, and if you have more questions. And I can't see you, so if you duck out, it's not like I'm going to notice you're leaving. So, but I'm happy to stay a little longer.
Yeah, let's keep going, I think.
Okay. Okay, so where was I? Say? Get your synchronization line. So putting on your website, something reasonable is up to, it's in the eye of the beholder, I guess. But certainly not a full movement. I mean, not a full piece, certainly. We had an interesting case with a doctoral student who wanted to include a work by Bernstein in her dissertation. The entire work is 32 bars long, and to really use it effectively, because it's an interesting rhythmic thing that was appropriate, she wanted to include the entire piece, all 32 bars. And oh my God, back and forth with the publishers a million times, like, the whole work? And we're like, yeah, but it's 32 bars. So if you only do like 8 bars of it, you're losing, a major chunk of what she's trying to do. So anyway, all I'm saying is there's no easy answer. There's not a set time limit. If you do 30 seconds or less, a minute or less, there isn't like 10%. So if you're doing the math, well, the whole performance is 15 minutes. So if I keep it under, you got to make that determination. So we anticipate you're probably going to post some clips. That's fine. You don't need to ask my permission. Be judicious in how you do it. But more importantly, think of your co-performers. If you are, performing whatever you do, you're singing with a pianist who's collaborating with you, you should probably ask them, you okay if I post this part of it on the web freely for everybody in the world to see? If you're in an opera and there are, several singers that you're collaborating with, or a string quartet, you certainly want to ask the other people in your ensemble before you do this, because nobody wants to hear that thing that they thought didn't go so well is now posted publicly, and they have to come to you and say, hey, get that thing down. I'll just add that one of the Joshua Bell things we did several years ago, I'm blanking on the pianist's name, but this was the first time they were going out on tour. And this was sort of just before they left for tour. They were giving their program here in the MAC. And there was this moment, which was fantastic, but I guess not so much for him, where they kind of got to a new section and the tempo changed. And clearly the pianist started not quite as quickly. It wasn't going as fast as Josh wanted it to. So when Josh came in, he turned to the pianist and just sped him up. And it didn't look terrible. But if you looked at it in that context, you realize, yeah, he was saying, hey, that's too slow. Let's go faster. And when we posted it, not thinking about that, and he wrote to us and said, hey, would you mind? I don't think I really looked too good there in that moment. And so, of course, we took it down. So, again, this is not legal. It's just really kind of an ethical thing that, again, these are lifelong colleagues, and you should always strive to do the right thing. And you wouldn't be happy if, as a faculty member found on YouTube once, where we used to have a guy who really liked the historical performance department, and he would go to all the concerts apparently and video record them from his seat and then post it all to YouTube. And Elizabeth Wright is the one who wrote to me and said, how did this happen? This is on the web and I'm not pleased with that performance. Take it down. I'm like, I didn't put it there. Who's that guy? And so we had to do the investigation, and we had to write to him and say, take it down. And he was so mad. He's like, I'm doing this as a service to your school because it's so great. And we're like, yeah, you can't do that. Stop. And took several back and forths with him. All right. We're going to move on. Just so you know, I've mentioned what a mechanical license is. So if you want to make a recording, like a CD or a digital download, a ringtone, anything like that. Now, we're not talking about video here. We're talking about audio. You should acquire a mechanical license. And this is really easy. And you go to this Harry Fox agency, and I will give you their URL at the end. And as long as it's been recorded before, the copyright law stipulates that the copyright owner of the work can't deny you this right to do it. It is a statutory thing. So, there's I think it's like 9.5 cents a minute or something is what you end up paying, times the number of recordings you intend to, back in when you're making CDs, you say, I'm going to make 500 CDs. The total is, it's 11 minutes. And so you do the math, and that's how much you pay, and that gets you the mechanical license. And you get it from this Harry Fox agency. You don't really have to deal with the publisher of the work. And that again is done by the copyright law itself. If it's never been recorded, the copyright owner of the work does get to dictate the first recording. So if it's never been recording, if it's not in Harry Fox's database, you got to talk to the composer or the publisher and work out a deal where they may want to charge you something for that. But after that, you go forth and make your audio recordings, commercial recordings. I mean, is what I'm thinking about there. If you wanted to release the CD or digital download or whatever. Okay. Okay, I've already covered that. Let's move on. Let's not waste time on this. Okay, fair use. I did want to mention this because all of this, right? You get licenses, you ask permission, but there is this thing called fair use. And what I would like to emphasize, and where I thought you guys were all going to go when I asked you the questions up front, was that, well, it's fair use. I'm a student, right? I'm a poor student. It's for my education. And with all the licensing we did this year, there was a concert that was being planned, and we said, well, we got to buy licenses for all that. And someone said, well, isn't there an educational exemption? We don't have to pay those kind of things, do we? And I'm like, there is no educational exemption. So we, as I said, we do make use of fair use when it comes to our digital library. And again, that's a closed system, although we do open up certain works that are in the public domain that we don't have to worry about. But we can't just put stuff out there on the web because we say we're an educational institution here to educate the world and do the right thing. If the Berlin Philharmonic makes a recording of Beethoven, they'll be a little annoyed if we start streaming for free a copy of it, right? That's just the way it works. But if we wanted to use it internally, we think that's a fair use. So just so you know what goes into making this determination, there are 4 factors that you have to consider. And this is the legalese here, right? The purpose and character of the use, whether it's commercial or nonprofit, the nature of the copyrighted work itself, the thing you want to use, the amount and substantiality of the portion you want to use in relation to the whole, kind of like what we were talking about with your putting your clip on the web, and the effect of the use upon the potential market for the actual work. So how does this play out? Let's look at these quickly here. So here's the first one, the purpose and character. So, the ones favoring fair use. So when you do say, yeah, I'm a student, it's for teaching, it's for research, it's for scholarship. It's not for profit. I'm not trying to, release a commercial thing here to make money. Or if it tends to criticism or parody, transformative use, right? That making something different out of it, but using this thing that is copyrighted as the basis of that. And it's restricted access, kind of like what we do for our digital library internally at IU, as opposed to it's commercial, it's for profit, I'm trying to make money, or I'm doing this and I know it's wrong, but I don't care. And so, come at me. Or if you're using it and denying the credit to the original author, especially. Now, crediting somebody, which you see on YouTube all the time, like, I don't own this, I give all the credit to the Berlin Philharmonic. Well, they don't care. That doesn't make it okay. But pretending that it's not someone else's, or that not acknowledging that it's someone else's, doesn't play well with so that's one factor. And again, at the end, it's not like there's a real score here. You have to kind of look at each of these and say, well, this one, it feels like it's more fair use. Like, I think this is okay. And then you look at the second one, the nature of the copyrighted work. Is it published or unpublished? Is it fact-based or highly creative? Something that is, if you're using something that is dealing with statistics or historical record or things like that, that's very different than if you're stealing someone, if you're writing about a wizard who goes to a school, with a whole bunch of other young wizards, and, already, you get what's happening there, right? Is it important for the educational objectives that you're trying to do something that's to be used in education, or is this completely fictional? You're right, that you're doing something that's not based. There's no educational exemption, but leaning towards education certainly helps your case. Okay, and the amount and substantiality, we could spend 2 hours talking about this factor alone. Obviously, a small quantity versus a large portion helps. But there are several cases where that doesn't mean anything. It's the substantiality part that really matters. There's a very important case of the memoirs of Gerald Ford. If you know who that was, he was the president who came after Richard Nixon, who had to resign. And I don't have time to tell the whole story, but a periodical, Time Magazine, I think, or Newsweek, published excerpts of that, and as magazines sometimes do in preparation for the release of this book that's coming out. And they were accused of stealing this other group's copyright, the book's copyright. And they said, we only had, they counted the words. It's like, 1,000 words out of a 30,000 word book or whatever. It was a paragraph. And the initial ruling was, yeah, it's the paragraph about how you pardoned President Nixon. That's the only reason anybody's buying that book, and you made it unnecessary now to go buy it. So that small amount, it plays out differently. That's why I can't say 30 seconds or a minute. 30 seconds of a 2-minute piece versus a minute of an hour-long piece. I don't know. So, okay, you get the idea here. And the last is the effect on the market, like that Gerald Ford memoir. What's the effect on the market? So if you do this thing and you make it available publicly, is someone not going to go buy that original? So, you write a piece, you write an arrangement of a piece that people no longer are going to buy the original. Is that works against you, right? Or is it so significantly different that it's not going to replace the original? Are you just making a couple of copies for a specific reason, or are you trying to mass produce this to make as much money as you can? Is there a way to license it? Oftentimes that's, again, sometimes we feel like, well, we tried to license it, but there was no way. We couldn't find the original owner, long story. Or is there an easy way to do it? Like, you make a CD of a copyrighted work, you can get a mechanical license really easily on the web and doesn't cost you a lot. You should do it. And do you own the original? Did you acquire a copy before you exploited it to do something else? Or did you kind of steal it in the first place? So all of these things go into this fair use thing. So when you say, oh, I think it's a fair use, do so, with probably more depth than what I just threw out at you. You'll have this chart. There's lots, you can search the web. Lots of law schools and universities have guidelines for fair use. You might want to consult a lawyer, but don't think that just because you're poor, you're a student, you weren't going to spend money on this thing anyway, that, oh, it's a fair use and I can do it. There is always, again, it's a risk versus reward thing. And remember, Gandhi said, peaceful disobedience, was okay, but you had to acknowledge you were being disobedient. And so, if you're going to break the law, it's okay to say, well, I'm going to do this because I think it's fair, or, I'm not going to get in that much trouble. But you got to acknowledge that, yeah, I now know what the letter of the law is, and I've chosen to go a certain way. Okay, that's the presentation. Here are these last two slides, all of the possible information you want. I do want to share that Naz Pantaloni has this really excellent guide from which I stole a lot of information at that URL. And I will send this on as as a PDF where you can just click on the link. So you'll have all these. That link to the recordings policy is there. Barbershop Harmony Society, I link to them, and those terms of service. Oh, I put that in the wrong place. Sorry, that slide's in the wrong place. And then the PROs and their databases. So these are the places you go if you want to search for works to see if they're covered by these performing rights organizations. And the Harry Fox Agency there at the bottom is where you would go to see. It's very helpful. Even if you're not going for a mechanical license, a lot of the works you'll find there that list the copyright owners, who the publishers are, or who the composers are, who you need to pay essentially if you want, or you need to contact to clear some of these works. That's it. So.
Wow. Fantastic. Woo-hoo.
If the dogs hadn't barked, I probably could have kept it to an hour.
It was
Sorry.
virtuosic.
Well, it's a lot. And again, you're probably more confused now than you were when you started. And I apologize, and you're welcome to contact me again. But know that, and it's always changing too. So ask me again next year, and I might say, well, now we're looking at that differently.
Yeah. So. Well, Phil, thank you very, very much. That was absolutely fantastic.
My pleasure. It was good for me to actually have to organize it in a certain way. So thank you.